Good evening, everyone. We will now have the final discussion of the day. It is my pleasure to introduce Silvia Zorzetto from Milano University, who will be delivering a talk titled Beyond a Reasonable Doubt, Precaution, Prudence, and Proportionality. And after the talk, as with the other presentations, Professor Keating will discuss Silvia's ideas. Okay. Your time.
Thank you very much. And first of all, really I want to thank you, all the organizers, the Cattedra de Cultura Jurídica and the Master en Derecho de Daños, y Diego Papayanis y Carolina Fernández Blancos y todo el equipo de Girona. My presentation is devoted to a specific, in a sense, part or topic of the book Reasonableness and Risk, and basically I will speak more reasonableness rather than risk. And I think that the book that we have the chance to discuss here today, and that I'm honored to be here, is very, very important for legal scholars and legal philosophers. And this, regardless the methods and also the legal systems for which they belong, I have learned a lot about the analysis of tort law in the United States, on which the book gives a wonderful fresco. And I think that it is a fundamental point of reference and full of thoughts also for the continental scholars, also considering the circulation of systems, models, and the many legal transplants that we try to make from the US experience. And I think that here I have not the competence to comment in detail the more legal part of the book that is very deep and very extensive. And so I would confine my observation basically to the more philosophical part of the book that I think is very illuminating, and that combines reflections that moves from the nature of law and the concept of law, taking into account also some metaphysical foundations in the sense of the tort law. And this, the value added of the book, in my perspective, is also that to combine, to join the more fundamental assumptions with a reading of the judicial sides of the doctrinal orientations and political ideologies of the legal design that characterize the US context, but that are very useful also for those that comes from another legal system. And and I appreciate very much also the approach of the book that, of course, is critics respect to some doctrines or some approaches. We have commented many parts of the book, and I refer in particular to some ways of conceiving the economic analysis of law, etc. But the way in which the criticism is purported is at times very moderate and constructive, and trying to save the good part in the sense that in each approach and in each proposal is put forward. And here I would like to make basically some more questions to the author, and all starts and turns around the concept of reasonableness that but I'm not sure that it is a right reading. It seems a central concept for all the theory of Gregory Keating. And I start from the book, from the preface of the book, where I skip the quotation, of course, to save time, because everyone has read the book and so knows the reference that I use. But basically, in the preface, Gregory Keating emphasizes that security and security safeguard regards the groundwork of our existence. And he wrote that the core of the law, torts, safeguards the very groundwork of our existence, the primary rights and the responsibility of tort law specify important and overlooked norms of basic justice. There is a reference also to John Stuart Mill in this quotation. And I wonder whether if this perspective is a result or has behind an anthropological or philosophical conception that has been emphasized, among others, by Hart when he speaks of the truths that underlie natural law. I mean the law, not natural law in some perspective of nature, but the law that takes into account the nature of human beings. And I think that in this respect, Mill's idea of the harm principle is certainly a political reference and is relevant for the normative proposal of Keating in his book. But it seems to be that his view could be also be compatible with the notion of the principle not interfering implicitly in a harmful way. It seems very close to the sensibility of Hart when he analyzes the vulnerability of human beings as one of the truths that characterize the structure of law. And saying another way, I think that considering the vulnerability of human beings, the problem of the reciprocal interference that we have is unavoidable, and is the problem that whatever law has to consider. It's not a necessary, this does not imply that a positive system of tort law designed in a certain shape follows and does not follow automatically. But the assumption is that we have this problem that is unavoidable considering human nature. And in this respect, the idea of Keating that the assumption is this problem of not harmful interference, it seems to be a sort of basic principles, and all the theory that Keating elaborates on is to understand the different options that we have to try to find possible solutions to this fundamental and, in a sense, metaphysical problem. And I find a sort of suggestion in this direction when, in the book, Keating's make a reference to the idea of time. And he wrote that, and he make a sort of comparison, in a sense, or analogy between torts and time, differing that from contract and property, and this it's very interesting, but it seems that torts has something more essential in the sense respect of some other institutions, and the torts scholars he wrote seems to be admired in a modest version of the predicament that St. Augustine found himself with respect to time. But this, that is, of course, a criticism with respect to some way in which some others see the tort law. On the other side, it seems to be defended by you when you put tort law as a priority, putting a priority of safety and security, respect to liberty, and then considering that as a sort of primary rights and responsibility, as you write, and it is the very norm of basic justice, considering humans as we are in a world where we need and we cannot not cooperate. And cooperation means mutuality, reciprocity, as you say, and this is at the core, there is the concept of reasonableness. And the second question that I have, that is close to this, regards if you think that in this respect reasonableness is maybe contingent or not respect to the principles that we do not, it is that we need to find justification for the interference that we have. You start from this question, but why reasonableness is so widely used? It seems that even if we try to escape from its use at the end of the story, we cannot avoid to use reasonableness when we have at the end to justify all the hard cases, all the situations in which it is not clear or if the interference is harmful or not. Because, and in many passages of the book, the problem is the justification. Interference are inevitable, and we have to find a justification to admit someone and some others not, to consider that some are legitimate and some others not. And it seems that at the end of the story, even if we use different terms, different doctrines, different models, but at the end, the grounds is the problem of the justification, and the grains at the end of the justification, the standard, finally, it seems to be in every time reasonableness. Both if we speak, and if we are in the field of negligence, of due care, or even of strict liability or precautions, at the end of the story, the final point is the problem of justification, and we express it conceptually, I mean, in terms of reasonableness. But I really would like, if this is completely a misunderstanding of your. And in this sense, my question is reasonableness a sort of universal parameter that is embedded in the principle that to regulate the interference between vulnerable persons when we have to justify this? Or do we have really different standards? And there are many points in the book, in fact, where you find a sort of synonymity between reasonableness and justification. Where you distinguish reasonableness from rationality and the reading that the economic analysis of law makes of rationality, but this seems to me to confirm the idea that these readings that you criticize a lot to consider rationality only instrumental and economically orientated is not necessary, in the sense it depends on the doctrines, on the different views that economists and those that study economic analysis of law may have, but it has nothing automatic or not necessarily link with a more philosophical, in sense, idea of that non-interference, non-harmful interference between or among vulnerable humans. where it's not a problem of, or not necessarily a problem of instrumentality, and not necessarily implied any economic model, and the original or the basic problem is moral. It depends on our moral intuitions about a sort of hierarchy that we put of the value of our life and our vulnerability. And another inches of this possible elements that are behind the text, in the sense, comes from the emphasis that is put on the physical harm. I mean, I was a little bit surprised, in a sense, that on one side you criticize quite clearly many approaches that emphasize the element of physical harm. But on the other side, in many other also development of your theory, it seems that this element is confirmed, and a part of the difficulty to distinguish from what is physical and non-physical, considering health and many other elements that regard typically and are protected by Torts law. But also there are some quotations in the book where on one side it is written that physical integrity of our person, our safety, is a primary good in the sense of laws, and that is the one that is considered relevant for the deontological view that is deployed in the book. On the other side, you admit in another passage of the book that considering the Millian proposition and his view, in this case, liberty, integrity, and also physical and physiological, psychological violations. And this quite different in the sense, not incompatible, but possibly different readings. It seems to me that make your theory more close to a perspective that belongs to the idea of heart rather than those of John Stuart Mill. And another comment regards the standard, in particular the duty of reasonable care. I do not have understood, or better, I would like to understand better if you construe a sort of a kind of lexicographical, to use the term of Rose, order between the basic principles of not harmful interference and the duty of reasonable care is one of the way in which we can apply this principle to try to specify it, or if it is another way to express the basic principle. And so the idea that in some parts of the books it seems to emerge that there is a sort of priority of reasonable care as a standard respect to all the others that are used or should be used in the tort law. I understand that, of course, the US environment is very heterogeneous, and there are lots of provisions, cases, etc., that are not in line, in a sense, or not perfectly consistent with your theory. But my question is not descriptive, but is normative. I mean, you make a wonderful description on what is going on, but your proposal is also to make a sort of to try to understand what you are doing and what are the different options that we may have to improve better a system of tort law. And so normatively, I would like to ask you to clarify which would be the place of the reasonable care in your the hierarchy, in the sense of principles and doctrines and specifications that in the template of reasonableness you put, and where it seems that you sum up some basic principles, the assumption, and then the many different and heterogeneous instruments that we have, and that you analyze very carefully, and from the use of some you agree, and with the use of someone else you disagree. Another question regards the where you speak about the test of reasonableness. It's clear that besides there is the idea, of course, of Rose that is quoted a lot, but you quote also the golden rule in one passage. And while in the book it seems that is not considered or not expressly considered the principle of universalizability.
Right.
And my answer is this, but simply it is implied, I mean, and so even if you do not reflect explicitly on this principle, you assume that it is part of your theory, because the idea of reasonableness that lies behind your book, it seems to me, that is grounded on the idea of universalizability, with the idea that we are of this mutuality, of this reciprocity, that as we interfere with each other and each one with whatever else, in each case we have to put each one in the shoes of the others to try to understand a fair term of cooperation, and to understand if and which would be a justified harm, and what is reasonable and what is not. And the exercise is precisely this. But if I were you, would it be justified what I have done? And this philosophical experiment, in the sense, it seems to strengthen the philosophical apparatus that is at the bottom of your theory. Okay, I want to. Okay, we have a few minutes. I skip some other arguments, and at the end, I would like to say something about balancing, because balancing is analyzed, of course, in the book very carefully, in some pages that show very well also the way in which courts use or do not use the balancing. And possibly here there is some differences rooted in the different legal culture or legal traditions, and it seems very useful also to have a sort of comparative brainstorming. And because now in civilian legal system in Italy and many European legal systems, but not only, reasonableness is one of the key concepts of balancing. Balancing whatever, I mean, balancing principle, balancing rights, balancing interests, balancing goods, etc., etc., etc. And so the problem is not the term of balancing in a sense, but about the instrument that we use. And balancing is considered and considered very successful technique, even if it is also very criticized due to a sort of excess of discretionality that leaves to the interpreters and to judges. And in the book, I have found many passages where it seems that you are sort of a little bit critical with respect to the use of balancing in the tort law. And I would like to understand if which are the reason, if my reading is right and possibly not. But the reason why I'm curious about this is that I have some difficulties in thinking that we can preserve this structure of the theory. I mean, this idea of the basic principle related to the non-interference of vulnerable individuals that is related to these fair terms of cooperation, the golden rule, etc. And at the end, thinking that we could skip at the end to use a structure as this balancing, that of course is a metaphor, is the metaphor of justice. But precisely because the balancing is the metaphor of justice, at the end the problem is the ones at the beginning. The problem is justification. And so in every case, at the end, we do not skip the final problem, that we have to justify the circumstance that our activities collide one with the other. Right. And we cannot, we would like to have a win-win solution. But this is just in the game theory, right. and not in the sense in the real life. Whenever we speak or we win result of the idea that when we balance principle, nothing is sacrificed or is we reach an equilibrium, something like this. It's another way to find justification that is related to each specific case, that is an occurrence of justice, and in another sense, in the common legal system, possibly we would speak of equity, and in a civil law legal system, we would speak of equitas. And so the other phase of the justice that is not the universal but the particular that we reach in each case. I stop here and really thank you very much for the very inspiring book that we have the opportunity to read and to comment.
Thank you. So let me take a crack at I'm just trying to figure out the order. Let me start with Hart. Yeah, Hart might be a subterranean influence here, and it would be great if I'm mostly compatible with him, because it would be a kind of overlapping consensus where I'm drawing on other people. The place where Hart has most explicitly influenced me is Hart wrote a paper called Natural Rights in I think Bentham and Mill. And that just clicked. I realized that's how I should think about interest with respect to rights. And the basic claim of that paper, as I understand it, is that we should think of the concept of a natural right as kind of a measuring stick, so that a natural right is an interest that somebody has that's urgent enough that we ought to construct some kind of legal right to protect it. And you can then see Hart as kind of bridging from Mill to me, but to other people who are important to me, in the sense that there's quite a bit of tendency to think about rights in terms of interest, for sure, but the other way is control over zones of discretionary choice, which is also in Hart, and both of those things are in law. Sovereignty, torts, or powers of discretionary choice being protected by tort doctrine. But what Hart there does is to think of, for the reasons he gives when he discusses the basic sort of conditions of the human condition and why natural law identifies them. You can understand natural law as clarifying those conditions to us. Is he's a bridge between the idea of interests and how you can make harm central to rights, so that the interest in avoiding harm can be what it is that grounds a right. And I think Hart is, Hart, if you go Hart to Ripstein, Hart's going to want to explain a lot of stuff that Ripstein's going to want to explain in terms of rights being the foundational notion and having no concept of interest and no concept of harm. Hart's going to say those things are all fundamentally about harm, that we recognize the rights we recognize because we're concerned with protecting people against harm, because people are embodied beings, embodied rational beings, if you want to be vaguely Kantian about it, and as embodied rational beings, that they're very physically vulnerable and they need protection against. We need protection against certain kinds of harm. And I think that is generally how I'm thinking about rights here. If we go back to Felipe's laying out of the structure, rights have compared to Ripstein or Weinrib or the hardcore Canadian Kantians, I have an idea of rights as an intermediate idea. They are, the fundamental idea is an idea of interest, and then rights as moral rights are picking out, we should count these interests important enough to have legal institutions, legal rights that protect them. And then legal rights are what articulate the obligations persons have to each other with respect to interference and non-interference, and that's, harm is fundamentally rooted in that. Those rights are fundamentally rooted in our interest in avoiding harm. So, and I suppose I think autobiographically, I always liked Hart and Mill, but I got pushed closer to them by reading Weinberg and Ripstein and so on, because I think they catch something that's very important. Let me try to go there to the physical and psychological harm. So for one question is, so what gives harm its moral significance? And there are different theories of harm that, at least in the American Academy and the Anglo-American, circulate. And the two most prominent are setback to an interest, where an interest is somewhat squishily defined, and the other is the impaired condition account of a harm. And tort law is quite drawn in American tort law to the impaired condition account of harm. First, it's preoccupied with physical harm. Over time, that's expanded, but it's very preoccupied with physical harm. Start in the middle of the 19th century when our modern tort law takes place. And that dovetails with the concern with the emergence of industrial civilization and the problem of accidents, but also with the idea that physical harm is maybe the core case of harm. And when you're impaired, and then how do you flesh this out as the reasons? Maybe this is a metaphysics of harm, but probably harm is not a unitary concept. We have different philosophical accounts of harm, because there really are different kinds of harm. But the one that seems to me to be the most illuminating for tort law is to say impaired condition, because that's what tort law says. Then to say when you're impaired, it's your powers of agency that are diminished. And that explains what's often called the harm-benefit asymmetry better than the interest account of harm does. And it's because the way in which physical integrity is a primary good is you need it. Same thing's true of health, which is a primary good for Rawls. I think actually integrity, physical and psychological also get on Rawls's list. You need these things, whatever else you need. And the more precise way, which will often be helpful, but sometimes forms of harm will be too heterogeneous and it will not illuminate it. The more precise way to think of it is your ability to exercise your will is impaired when you're harmed and you're put in an impaired condition. You simply cannot exercise your will through your body, because that's the first way in which you exercise your will. And can you get to psychological harm? I think the answer is yes. It will help you in some important ways with respect to psychological harm, but only up to a point. It's true from the psych literature that the kind of people rebound from all kinds of harms. It's not really a topic of mine, but it relates to no doubt, what I'm interested in. But the one they most don't rebound from is chronic pain. That is, people don't report restoring to levels of happiness after serious harms 5 years later when it's chronic pain. And one thing you think about that is, well, chronic pain really does disable the will, because you're simply not, it intrudes upon your consciousness in such a way that you're not able to impose your will in the world in the most ordinary sense. You know, you're constantly psychically, there's a wedge between the way you want your experience to, what you want it to answer to, and what's being imposed upon you by the experience of pain. So you can think of pain as, which you can think of as psychological, as an assault on your powers of agency and on your capacity to exercise your will. And then I think you can extend beyond that into important cases that are recognized by American law, because the way American law has evolved is it has expanded its recognition of psychological harm up until about the mid-1960s, and then it kind of cut back, slowed, but tries to edge forward now. And the forms of harm it gravitates to are things that we might call psychologically post-traumatic stress disorder. So that if a mother witnesses a negligent driver running over and killing her child, she suffers post-traumatic stress disorder. And you can think of that as, that's a real impairment of your powers of agency. Now, somewhere, I think you're getting beyond when I start thinking about these harms. It's not clear what the best notion to characterize it is, because it is a sense when you think of people, and you think of people you know who suffer events like that, they're just not the same person afterwards. Part of their life has been impaired by what we're classifying as emotional distress. And the impairment of their life, I think, is being marked by the psychological harm. It's the intertwining of a parent's life with a child's life that means the death of the child is a harm to the parent, and that's the root of the impairment, and the distress marks it. So you get some of what I want to get. The idea of impairment will take you pretty far, and it will give you some guidance with respect to, if you think the fundamental problem tort law faces is you can't allow recovery for all emotional distress. If you think of emotional distress, somewhere in Middlemarch, George Eliot has a line, "We would die if we heard the roar on the other side of the grass growing," which is kind of Joan Didion-esque line, but one knows what it means. And so distress is this fundamental part of the human condition, but picking out the core ones by which ones are impairment seems to me to be a useful way to go, and I think it coheres with the idea of harm I'm mostly using, and the one that I think fits the most with tort law. So let me then try to turn to, I think your questions about reasonableness, reasonable care, balancing, and rationality are all kind of linked. So first, one way you might understand reasonableness, and I think John Gardner understands it this way, it's just about justifiability. And I think, yes, it's definitely about justifiability, but I want to say it has more of an inflection that Sibley and Rawls pick up, which is there's a certain resemblance to the categorical imperative in that this particular concern of justifiability is that you act in ways that can be justified to others who are affected by your actions, and that's the connection to the intuitive idea of the golden rule, which shows up in all kinds of moral systems, but that if were you to change shoes with the person that you're imposing the risk on or the harm on, they would be prepared to accept the principle on which you're acting. So I think that's resonance of reasonableness goes beyond just justifiability, because you could have a pure utilitarian idea of justifiability and it wouldn't have that resonance of justification to others. It wouldn't have that what we owe to other people resonance. Now, let me just take rationality. I think there are very rich theories of rationality that could lead to quite a different conception of tort law. I suppose if you start with Aristotle and took ideas of rationality, you'd get some very interesting things. And there may be places inside American tort law where ideas like that are actually at work. That is when I don't discuss this much, but sometimes we relax duties of care, like in what's called primary assumption of risk in American law with respect to primarily sports. Mm-hmm. And what you can think there is that there are activities whose intrinsic value cannot be realized if you demand the reduction of risks to a normally reasonable level. I'm not going to give an example that isn't particularly good for illustrating tort problems, but illustrates this. Climbing K2, all right? You cannot pursue climbing K2 and think it's just going to be as safe as sitting in this room. And you might think that these things fit in a very broad conception of a rational life plan because there are values that a rational person might want to realize that can only be realized that way. And so on a very broad notion of rationality, you could fit those in. I am using a narrower one for two reasons. One, I think American tort law really does use the notion of rational prudence and some famous case rhetoric. For example, early cases trying to explain the duty of reasonable care say, how would you conduct yourself if you owned all of the interests affected by this risk imposition? That demoralizes it. It reduces reasonable care, which is an interpersonal thing, what do you owe to others, to what would a single rational actor prudently do. And that's one of the resonances that rationality has. It's a very powerful resonance. I think the economic tradition in the United States really picks up on that. The law in economics wants to totally, in its normative mode, demoralize tort law and turn it all into the pursuit of some kind of rational self-interest that's welfare maximizing. And so that contrast is because economic analysis dominated American tort theory for about 40 years. That's the one that I latch onto. But you could have a much richer notion of rationality, and if you started looking around, you might find evidence of doctrines that were shaped by it. I don't really touch much on that in my book. Let me then try to turn to universality and then go through reasonableness and balancing. So the idea of universality, it's one I've pondered. I had some tests of universality in earlier writings that I wound up purging as I went to the book. And mostly it was there's something there that I don't have under control, and so set it aside. There seem to be two kinds of problems. One is when you try to explain where something's universalizable and you start looking into the literature, going to lunch turns out to be a very complicated problem to describe, because what do I say when I go to lunch at noon? Can everybody go to lunch at noon? Would it be impossible for anyone to go to lunch at noon if everybody went to lunch at noon? That's clearly not what we're concerned with. So the question is, how do we get into this problem? And an alternative way to think about it is that universality is actually a point about the metaphysics of certain kinds of moral and legal norms that you quote Sidgwick, I think. And Sidgwick, who couldn't be further from Kant in very important ways, is, I think, invoking a metaphysical idea of universality, which is what I claim when I claim I'm acting in a morally justified way is that anybody in my situation, and that's where the act description problem becomes so difficult, should act as I'm acting. And I think that's actually a point about the metaphysics of a moral norm as opposed to a norm of prudence. So I would think all my points are compatible with that, but I'm not trying to impose what you sometimes see as tests of universalizability, which there's a literature coming out of the category of imperative that tries to figure out how to describe actions in such a way that you can tell whether they run through a filter. I had some of that in earlier iterations of my thinking and backed away from it because I could never solve the description problem. Now, going to the sort of reasonable care and then I think the balancing, you can think of reasonableness as a master notion because it's a way of the master notion of, because you can think of rationality as a master notion in a certain branch of economics, which is we're concerned with conducting ourselves rationally to maximize value. And reasonableness is a master notion of thinking, how should we think about what we owe to other people? It's about, it gets articulated in different ways, like in Rawls or Scanlon, in quite more detail than I don't try to draw on that in great detail. You wind up very deep in philosophy and further away from tort law. But that is the master idea I'm accepting as a kind of orientation. Can we justify our conduct to other reasonable people who are prepared to act on principles we could both accept and so on, those kinds of ideas. So you can see of it as a master idea. And then it gets lots of different articulations in tort and related fields. So in tort law proper, it never really gets specified or gets articulated in a way that fleshes out the moral content of it because of the role of jury adjudication. We basically kick things to juries and we give them, in theory in the United States, jury adjudication is very wide-ranging. Cases are actually jury cases, even if no reasonable people could disagree about the facts. As long as reasonable people could disagree about what was required in the way of care given those facts, which is an unusually broad standard for jury adjudication. But an effect it has is to leave it to juries to say what reasonableness is. And so when courts develop doctrines, there are these isolated doctrines, for example, that statutes can only be violated when what you're doing averts more harm, which is a kind of interesting idea, but an isolated idea. And statutes are given certain kinds of weight, and customs are given certain kinds of weight. But in some sense, what the law is doing there is drafting on these independent sources of norms of coordination and precaution. It's not trying to spell out the content of reasonableness. I think regulatory norms in the United States do, and so then I discuss in one chapter what's called the safe level norm, or I call it safe level norm, the feasibility norm, and then the cost justification norm. And I think all of them have places in a view like mine. So in a first best world, you'd want to hit universal safe precaution. And safe precaution is just, there's a minimum level of risk that's unavoidable because of what you said at the outset about human interaction, vulnerability of bodies, and that so that there's nothing, not even crawling under your bed every day, that would eliminate the risk. So there's some kind of minimum level of risk that's just imposed by activities. That would be the safe level. Often we have to depart from that. If you take Boomer as an example, tons of stuff in our industrial and technological civilization is not safe. And we probably way underrate just how much it isn't safe because we don't fully understand the causal connections between all the processes we engage in and the harms they cause because they're not coming through physical impacts, they're health effects and so on. But sometimes we get them very clearly in view. And when we say, well, we can't give up the activity because it's too valuable, we move to the feasibility standard. And I think of the feasibility standard as being a pretty powerful articulation of what reasonable care calls for, in contrast with the economic emphasis on cost-justified care, because I think what feasibility picks out is we need safety. It's a needs kind of standard, whereas the basic thinking in American law and economics is a wants-based view. And needs can just take a priority over wants. So we go beyond the point of optimal precaution from the point of view of cost-benefit analysis because we need something like safety and we're willing to push a risk down to the point where we jeopardize an activity that we think we also need that activity. We can't give it up, okay? And Boomer illustrates that pretty nicely, I think. And then finally, there's a place for straightforward cost-benefit analysis with maximizing at the margin, but you have to say that the values at stake are not life and safety. It's ordinary commercial property that's at stake in Vincent v. Lake Erie. And when ordinary commercial property is at stake, I think we would be sentimental to think that we should take more than cost-justified precaution against harm to ordinary commercial property. That's in fact, the property is fungible, its only value to us is its use value. The value can basically, after the fact, be replaced by dollars. The economic way of thinking about that in efficiency terms is the right way to think about it. And to the extent that I have a sort of developed view on balancing, it would be essentially that these three standards are the boxes we should fit our thinking about risk into. And then when we turn back to the common law, where it isn't articulated by courts, because so much is punted to juries, I want to argue, to the extent we can pick out threads in runs of famous cases, courts do assign disproportionate in terms of trading off at the margin, is that's the picture you're working against. They assign special value to security. I think, for example, the very famous punitive damage case in the United States involving the Ford Pinto gas tank is a case where the jury's intuiting, no, with respect to a gas tank, you should take feasible precaution. You should make the gas tank as safe as it can be without giving up to having a subcompact car. You don't have to produce a tank or something like that, but it's, you should take feasible precaution to make it as safe as possible. And it is a fundamental moral mistake to trade life off against all other goods at the margin as if they're all fungible at some rate of exchange. So I think there's evidence that there are intuitions like that that pop up in jury verdicts, but juries are black boxes, and therefore we don't have the articulation of their reasons in the way that we do when we look at federal statutory standards and courts are applying criteria of risk regulation.
Okay, thank you. Now the room is open.